But what about the poor defendant? Who's going to look after them? Hi, and welcome to this short episode in a mini series that I'm going to do on criminal law defences. In particular, these videos go out to Elle, or Random4102, as she's known on YouTube, who left a really nice comment on the channel the other day. And I hope that this video is useful not only for her, but for other people studying criminal law as well. In particular, this episode is going to focus on what is often called public and private law defences, but I think most people know it as self-defence. And I'm really looking forward to doing this series, so let's get started straight away. So self-defense covers three key areas. There's defense of the person, which used to be covered in the common law, defense of property, which was covered by the Criminal Damage Act 1971, and self-defense in relation to the arrest or prevention of crime, which was covered by Section 3 of the Criminal Law Act 1967. Now, in 2008, the Criminal Justice and Immigration Act was passed, and Section 76 of that Act, in particular, basically codifies all of the previous law into one very straightforward and simple section of legislation. So if you are really stuck in an exam and you have a statute book with you, or perhaps you're sort of 10 minutes away from the exam and want to do some last minute revision, then section 76 is relatively short, and you can probably just have a quick read through that, and it should actually give you all of the information that you need to know, or at least give you a bit of a reminder. So self-defense really asks the following question, and this is the key question that we're going to keep in our minds as we go through. Was the force used reasonable in the circumstances as the defendant supposed them to be? Now, if we break that question down, it basically comes down to two elements. Now, the force, and in particular, was the force used reasonable, the first part of that question. So in relation to force, we have an objective test, and then if we look at the rest of the questions, the circumstances as the defendant supposed them to be. So in terms of the actual circumstances, or the context, as I've called it, surrounding self-defense, we're performing a subjective test. So we're looking at what did the defendant actually believe to be the circumstances. So those two key aspects, and we're going to take a look at each one in turn. First of all, we'll do force, which is the objective test, and the idea of an objective test was really confirmed in the key case of Owino, 1996. Now, in the interesting case of Palmer against the Crown, Lord Morris kind of made the point that if the defendant did believe that the force he used was reasonable, then that might be given as evidence, but ultimately the test is an objective one. So we're looking at what would the reasonable person consider the force that was used to be reasonable. And although other evidence can come into play, ultimately that test is the reasonable person test. So factors that the court or you might want to consider if you're doing a problem question are twofold. So we've got the nature of the force, for example, the weapons used, and also the degree of force, so how much force was actually used. So Crown against Lindsay from 2005 is a really interesting example. I'll give you the facts of the case, and then you might want to pause the video, have a think about the nature and the degree of the force, and then unpause it and see what happened in the end. So in Crown against Lindsay, 4 home intruders or burglars broke into someone's house. The person realised that they were coming into the house and got out a sword and basically chopped one of them to pieces before the other 3 ran off. And the question in the case was the force used reasonable? So you might want to pause the video, have a quick think about it and come back. And coming back to the case now, if you've unpaused the video, in Lindsay they actually decided that although we can look at the nature of the force, so the weapons used, and we could say that that was reasonable. So what I didn't tell you in the case was that the intruders had guns with them. Use of a sword against guns, I guess you could sort of balance that out and say that the force used probably was reasonable. but the degree of force that was used, in other words, killing someone for intruding into your home, was decided by the courts not to be reasonable, and so the defendant was found guilty and they went to prison for 8 years, I think was the sentence that they got. Now, again, you can see how different courts might make different judgments at different times, and you can see how sort of vague this test really is. I'm not sure that I would necessarily agree with that judgment. If someone came into your home and you weirdly happened to have a sword with you and went full Kill Bill on that person, is that fair? Would you say that's reasonable? I think a lot of people probably would and would support you if you did kill someone who had broken into your home and was threatening you with a gun. So you can see that the question of what is reasonable force is sort of questionable and quite broad. And I think that the other factor to consider is that the scales that we use, we're not using a fine set of scales. We're just looking at the question broadly. So that's something to consider, and we'll look at that a little bit later on as well. Let's move on to the second part of that question. So we talked about the force used being an objective test, but what about the context or the circumstances surrounding it? And we sort of decided that this was a subjective test. So we're looking at what did the defendant believe the circumstances to be. And the idea of this being a subjective test has been around for a long time, really first established in Gladstone-Williams in 1984, confirmed in Beckford against the Crown in 88. And then, as I said at the start of this video, it's been codified in Section 76 of the Criminal Justice and Immigration Act 2008. Now, obviously, because this is a subjective test, it can sort of potentially lead to some strange conclusions. So if you imagine going about and seeing someone taking the shopping off an old lady, now one person might think that that young person is helping the old lady, another person might think that the person is robbing the old lady, and people might react in different ways, helping the lady out. So we can see how circumstances can differ based on who you are and what your personality is. And this means that in the actual court case, we can actually look at what the defendant is like as a person and ask quite prying questions into their background to get an understanding about how they would perceive the circumstances. So we can look at potentially the psychiatric makeup of the defendant. This was decided in the Martin case from 2000, where it was found that the defendant had schizoid affective disorder. But this idea of looking at the psychiatric makeup was questioned on policy grounds in the subsequent case of Tony Martin 2002. So it's not really clear whether we can look at the psychiatric makeup of the defendant. But what Tony Martin case did look at was the physical makeup of the defendant. So if you're feeling threatened, if you're a feeble old lady, for example, you're more likely to feel threatened by a home intruder than you would if you were a 26-year-old bodybuilder or someone like that. So we can look at the physical characteristics, and also the Law Commission themselves have pointed out that it might be worth looking at the relationship with the victim. So if it was a particularly close relationship with the victim that the defendant had, then that person is going to know more about the circumstances than someone who's just met a random masked person who's entered their house. So a few things that we can look at when looking at the defendant, but as we said, this is ultimately a subjective test, and the important question is, what did the defendant believe the circumstances to be? So we talked about right at the start about how there are three different elements of self-defense in relation to the person, in relation to the property. But we've not really talked very much about how it relates in relation to arresting or prevention of crime. And we can still look for this back to Section 3 of the Criminal Law Act 1967. And there's a few other factors that we can look at. So we've already talked about the nature of the force, for example, the weapons used and the degree of force. You know, is it a lethal amount of force that's used, or just enough to be necessary to stop the victim? But in relation to preventing a crime, we can look at the seriousness of the crime being prevented and the possibility of preventing the crime by other means as other factors. So we can look at this a little bit more on this side. So harm will only be reasonable if it is necessary to effect the arrest or prevent the crime. So we have to be stopping a crime to use the self-defense defense. And also we have to look at what the defendant is actually preventing. So if the person sort of pushes someone off a cliff because they're about to throw a stone at someone, then that's possibly an unreasonable use of force to prevent the consequences of their actions. However, if someone has a loaded gun and is about to sort of shoot someone, then if the police or someone else killed the victim, sorry, then we could argue that that is enough because you're potentially killing a life to save a life. Now, again, I've just talked about how the police could use this self-defense version to kill a victim. And this obviously has relations to Article 2, the right to life under the European Convention of Human Rights. And the European Court on Human Rights has basically said that the police can use lethal force if it's to help stop someone who is killing people. So, I mean, the obvious example would be the horrible attacks with the truck in Nice that happened the other day, where a person who was apparently affiliated with the Islamic State group drove into into a huge crowd of people who were celebrating Bastille Day. Now, the driver of the truck, who was killing these people, was eventually shot himself. And so we could see that the police in that instance were reacting in self-defense, and I don't think anyone would actually prosecute the police in those circumstances for murder. However, Nachova in Bulgaria, which is a 2002 case, basically says, okay, that's fine for where the victim is killing people, but for other sort of crimes, especially non-fatal crimes such as burglary or fraud or something like that, then it's not fair to use lethal force against someone. And again, this question about what is reasonable force is a very broad question, and this is a really good quote, probably my favourite quote from this area of law, and it's Justice Geoffrey Lane in Reed against Wasty, 1972. And it says, in the circumstances, one did not use jeweler's scales to measure reasonable force. In essence, we're not taking a precise measurement. We're looking at the question broadly and sort of trying to say, well, okay, we're reasonable people. What would we consider to be reasonable force? So if someone came at you with a knife and the only thing that you had to hand was a steaming hot iron, and you decided to hit the defendant around the face, the victim, sorry, around the face with it, then I would say that that's probably reasonable force. You've just grabbed something that's to hand, you're defending yourself, and that seems like fair self-defense. Other people might see that differently, but we're trying to sort of get a broad idea for what reasonable force is. So before I finish, there's a few other considerations for us here. In particular, I probably should have said this at the start, but the burden of proof is with the prosecution to disprove the defence. So if a defendant does raise self-defence, then it's up to the prosecution to disprove it for them to be successful. I've already talked a little bit about Article 2 of the Convention, the right to life, but obviously this is taken seriously, and if self-defence can be used to effectively justify murder, then we have to look at the test closely, and some have criticised the subjective element of the test, i.e. the way that the defendant perceives the circumstances surrounding the incident. And they've been quite critical of that and said that where we're justifying murder on these grounds, we shouldn't allow any subjectivity. It should be based on what the reasonable person thought, so that people can't just get away with killing people. Now, the court hasn't addressed this directly, but they had the opportunity to address it in Bubbins and UK, which was a 2005 case, and they decided not to. So we can probably pretty safely say that the test does stand up to convention standards. Also, retreating from confrontation. So there used to be a duty to retreat effectively in relation to self-defense. But that's not the case anymore. So the Crown against McInnes 1971 was probably the first case that said there isn't a duty to retreat. It's more one of the circumstances that they might consider in relation to the overall crime. So it's more of a factor rather than a rule or a test. And this fact has been codified recently in section 76(6)(a) of the Criminal Justice and Immigration Act 2008. This was added in by the 2012 Legal Aid and Sentencing and Punishment of Offenders Act, and basically confirms the idea in McInnes that while there isn't a duty to retreat that's based on rules, it can be one of the circumstances that they look at in terms of the context of the case. Preemptive strike was looked at in Devlin against Armstrong 1971. So if we go back to an example, if someone comes at me with a knife, I don't actually have to wait for them to stab me before I react in self-defense, which is pretty obvious, but it's worth pointing out and something to consider. Also provoked attack. So if someone's acting like a bit of a tool and is provoking someone to attack them, and then that person does attack them, then the question is, can that person still use self-defense? Now, the answer to this question quite simply is yes. You can still defend yourself, but only when the person sort of goes above and beyond to what is provoked. So say you're taunting someone at like a football match or something like that, and they come over and start battering you with a chair, or they pull out a knife, or basically just go completely over the top. Then in that circumstance, you can react in self-defense. It would be unfair to leave a person completely vulnerable just because they've acted like an idiot in provoking the attack in the first place. Final point is lawful force. So when a person believes that they're being unlawfully arrested and the police are either not who they say they are, or they're arresting someone wrongfully, then you can resist that. And that was the point that was raised in the Crown against McCoy, which was a 2002 case. One of the cases that I forgot to put in the presentation, but is really interesting and might be useful if you're writing an essay question, is Re-A conjoined twins from the year 2000. And in this case, which is quite horrible in terms of the circumstances, involved conjoined twins who were both potentially going to die because of the way they had been born. Now, it was possible to save one of the twins, but that would require an operation that would certainly kill the other one. And so the courts were left in a horrible situation where they had to try and find a way to justify the killing of a baby in order to save another life. And they eventually did this, and they used the idea of self-defense. So even though the weaker baby wasn't committing a crime, obviously because they were too young for a start off, they were inevitably denying the life of the other twin. And so they did actually use self-defense, the reasoning behind that, to justify the operation, which eventually I think did save the life of the other twin. So a really interesting case for you to maybe go and have a look at if you're writing an essay question. If you're writing a problem question, I hope this lecture was useful for you. I know I didn't maybe cover as many cases as I normally would do in a lecture, especially for criminal law, but there are a range of factors that I think you can consider from taking it from a problem question. So the opportunity to look at how the defendant perceived the situation in the first place. So does the defendant have any particular qualities that would affect the way that they saw the situation? And we might be able to mix this up a little bit with intoxication that we'll look at as a defence in the future. but also looking at the reasonableness of the force. So looking at the weapons that were used in terms of the nature of the force and trying to weigh up the balance there, as well as the degree of force used. So if someone was sort of threatened in a very mild manner but responded with lethal force, we could say, well, that's unreasonable. And so the defence of self-defence would probably fail in those circumstances. So not many cases, but a lot to consider. I'm looking to cover other defences in the future, so look out for ones on things like insanity, intoxication, hopefully duress as well at some point. And if you enjoyed this video, then definitely try and give it a like and subscribe for those other videos I've mentioned. If you have any questions at all or suggestions for other videos, then as ever, leave those in the comments below. Thanks very much for watching. Bye!